keep the bond as it is, Your Honor. Listen to Mr. Navy and Mr. Wallace.
Can I respond to some of his remarks, or do you go around?
Well, I'll take your response, but then we need to get over to, I believe, Mr. Navy is next. Yes, sir.
Your Honor, in this case, there was held a preliminary hearing, and Officer Robinette, who was one of the investigating officers, testified at that hearing. And so I would take issue with how serious this gal was hurt. The evidence, I think, in the case will be that she had a cut over from down onto her nose. I think the evidence probably will be, and we don't have, although I pointed out in my written statement to the court, the hospital or medical records. They're not here to show you how bad she was hurt. And I say to you that I think the evidence will disclose that this was a random thing that occurred. I think that the evidence is going to disclose to you that she has exaggerated tremendously her hurt. The injuries that were testified to by Officer Robinette is this cut that she had. They had an abrasion under her chin, and he testified that she had been taken down the hill to where the ambulance was that did take her to the hospital, and they had raised her shirt and took pictures of her back, and that there were markings on her back. And when asked whether or not these injuries to her face and nose could have been caused by a fist or a knee or a foot or some implement of the human body, he said, well, yeah, yes, they could. And when asked concerning the markings on her back, he testified that yes, they could have been caused by her rolling and scraping along in the rock and gravel that was on this road where this alleged incident took place. So yes, we take serious exception to how, at this point, as to how serious this gal was hurt. And again, I say to you that with all the tales that she has told, and some of which I've talked to people, I'm going to be able to show that she's not telling the truth in so many instances. And you can take her motivation and what she was up on that hill for and develop a scenario where nobody lured her up there, perhaps. I know she claimed she was lured up there by one of the defendants. And she's made several statements that I believe is going to come back to haunt her as to her credibility and veracity in this case. She says she's scared to death. I don't think she's scared at all. I think she may say that. And if you let Jennifer Bragg out, I can just about assure you that under these conditions, nobody's going to have to worry about Jennifer Bragg doing something of a violent nature to them. I don't think that it's necessarily appropriate in this case, but I feel that the court ought to set a reasonable bail that Jennifer Bragg can make. And Jennifer asked me, though, to put in the statement, because of not knowing what the court might do, that she would even accept home confinement. Now, to me, the way bail has been set, the nature of this case, and what has occurred and what this gal has told here and there, makes me feel that a bond, maybe in the amount of $30,000, $40,000 to the outside, I believe my client could make that. But there's no way in the world that my client can make a $100,000 bond or a $300,000 bond, and this case don't deserve that kind of bond. It's just not there.
You know, one of the things that you didn't respond to is what the prosecutor brought up about her previously being on bond and the fact that those bonds are
Oh, let me respond to that.
subject to forfeiture.
Let me respond to that. When you go up to those bond conditions, it says that she won't violate any law of the state of West Virginia. Well, just because the police, the law enforcement has charged her with something, does not mean that she's violating any law of the state of West Virginia or the federal or what have you. And so the net result is she hasn't done anything that should be alluded to as having to do with any violation of conditions, any bond. She's presumed innocent. She is innocent until proven guilty.
Well, bond is a civil matter, not a criminal matter, in the sense that the violations of the laws of the state of West Virginia have to be proven by preponderance, not proof beyond reasonable doubt.
Well, I understand that, but still, Your Honor can view my point that nobody has found her guilty on those things, and so what is the logic in presuming guilt? There's none.
All right. Thank you, sir. Mr. Nady?
Well, I was hoping I could get up right behind Mr. Green when his argument's still hot. Because most of his argument really is a very well thought out argument for bond in general is applicable to all three of them, except for the records, criminal records. The prosecutor said that this wasn't, he didn't believe, the state didn't believe this was a random act because Jennifer Bragg apparently had a history with the victim. But Jennifer Porter clearly doesn't. I think the state's acknowledged that. I think the victims acknowledged that. I think the victim in certain newspaper accounts and television reports that she's done, with voluminous reports, said that she didn't have any idea who she was.
I'm sorry. The victim said the victim didn't know who the victim was, or the victim didn't know
Who Jennifer Porter was.
Jennifer Porter.
Yes, I'm sorry.
Thank you.
Furthermore, Judge, and this is clearly not a legal argument, but there's been water cooler evidence statements made flying all over the place that certain co-defendants have completely exonerated Jennifer Porter in this matter. And I've had discussions with the state, and I believe the state's position is that she was pretty much in the wrong place at the right time. Jennifer Porter. She has no criminal record to speak of, a few misdemeanors. I think at one point early in the decade she was charged, last decade, with a felony that was not convicted. Lifelong resident of Lincoln County. And I think one of the most compelling arguments Mr. Green made too is I think these incidences are so related that it is almost an additional bond for the same offense. The constitutional arguments I think are the most compelling arguments as well, Judge. This is really a high bond given the circumstances, facts and circumstances surrounding this case. She has the ability, Ms. Porter, to post bond with the special condition of home incarceration. It really does seem to be the logical case in this matter, and we would just ask the court to reduce it in the area of $30,000. That's the resources that she has to post, and we'd ask for the judge to consider doing that in this matter.
Mr. Prosecutor?
Judge, I don't have anything to add from my other argument, and I agree that it's the other two defendants that have had a prior relationship and back and forth as opposed to Ms. Porter. I'm not going to dispute that, but I believe that to be true. But again, the same thing to be said that the victim continues to state that Ms. Porter also is one of the people that assisted in the beating of her. So, I would note that I don't know of any real prior relationship between the victim and this defendant. It's the other two defendants who had a substantial prior history with the victim.
All right. Thank you, sir. Any response?